everybody. Very warm welcome to you from a very cold Gauteng. It's great to see everyone here this morning. It is now 9 o'clock on the dot. We are going to get started with the presentation now. As people are still joining, Nadia will be admitting them from the lobby. Today's presentation, how to mitigate and eliminate legal exposure for your business, and we call this presentation Conquering Legal Blind Spots. Folks, today's presentation is going to be fairly practical in nature. We have thrown the presentation open to several industries as well as members of the public, so please do not expect a long-winded legal lecture going into great depth in terms of legislation. We will be touching on one or two legal issues which are obviously inextricably linked with the subject matter of today's webinar, but I am hoping that the webinar today will be a bit more practical in nature and will give you a little bit of food for thought in your own business. By way of introduction to those of you who have not yet met me, my name is Mervyn Vermeulen. I am an attorney, but primarily I would like to think that I am a businessman, and I am very concerned with the intricacies of running a business and specifically a law firm. This is a topic I'm very passionate about, and in the last couple of months I have realized to a very great extent the various blind spots that could exist whilst keeping one's eyes on the road as a business owner, a manager of a business, director of a business, etc. Hence the idea to run today's presentation, and I hope it will be of value to you. Just some housekeeping as I welcome you to today's webinar. Please feel free to type your questions in the chat bar, and please enjoy today's presentation. For those of you who would like to and who feel comfortable doing so, you're more than welcome to also introduce yourself in the chat bar to fellow attendees. Since we are using the Teams webinars platform, you will note that you're regrettably not able to activate your camera or your microphone. The reason for that is that we are recording today's webinar for purposes of sharing on social media, and we do not want to compromise anyone's personal information, etc., by allowing videos to be on and microphones to be on. So, for those of you who are wondering what is ThinkLegal, I'd like to just acclimatize you to the ThinkLegal initiative. It's an initiative launched by my firm, Vermeulen Attorneys, where we foster the idea that sharing of legal knowledge should be open to everyone. And I'm paraphrasing what I've got on the screen. Whilst we acknowledge that legal services rendered by attorneys is inherently a commercial venture, we do uphold the notion that legal knowledge, however, is a public resource and that everyone should have access to know about the law. Adhering to our dedication to facilitate open dialogue and share knowledge, we organize a variety of activities. We have 2 WhatsApp groups currently running, which I'll tell you about shortly, and we do run regular webinars, and of late, as I'm clearly a sucker for punishment, social events, which I'll tell you about a little bit later. For those of you who are not yet involved on the WhatsApp groups, you're more than welcome to grab your phone, activate your camera, and scan the QR codes on the screen now. It will furnish you with a link which you can follow to join our WhatsApp groups. This is the QR code for the family law WhatsApp group, and the following is the commercial litigation and labor law WhatsApp group. If you are not quick enough to snap it, don't worry, I will be distributing the slides from today's presentation in PDF format to everybody. So let's get on with it. And I'd like to start today's presentation by answering the question, what is a business blind spot? First off, you'll see I wrote blind spot as a single word. Google disagrees with me. It seems to think it should be hyphenated or two words. It may be right, it may be wrong, but for purposes of today, I've put it as one word. You're welcome to correct me in the comments if I am mistaken. So what is a business blind spot? Now, folks, we know that running a business is very much akin to driving a car. You need to keep your eyes on the prize, essentially pursuing your primary core of your business. If you are in manufacturing, your focus is on the manufacturing process and ancillary issues there too. If you are in the services industry, the same story in terms of services. If you are in the retail industry, your focus is on selling goods in the retail space. Very often, however, we forget about K53 and we don't have a look at our periphery. And to that end, I'd like to share a video with you, if it permits. I'm going to mute the sound on the video because the sound really doesn't add much to it. But if you will give me, just indulge me for 30 seconds, I'd like to show you the following video by way of introduction. This is a French advertisement for road safety, but I think it is very, very illustrative to our purposes. It just shows, in terms of a truck driver's visibility, the inherent dangers potentially around the driver, which are not necessarily visible to the driver as they're sitting in the driving seat. Much the same as business owners and business managers, there are various other risks out there. We are very often swimming among sharks without realizing it. And I think let's start with some cautionary tales, which I found on Google yesterday, some of which were amusing, some of which were just plain sad, but let's run through them. Cautionary tales, I suppose, folks, at the moment would not be complete without reference to Eskom, and we're talking about Eskom debt relief. They are sitting with an unsustainable 423 billion rands worth of debt, which I do believe would have been ameliorated to a great extent had there been more focus on the hidden peripheral issues, and I'll go into that a little bit later. Another big cautionary tale, and I think the attorneys who are in today will probably start sweating profusely at me mentioning this, and that is FICA. Now, I've given you a few cautionary tales on FICA. Let's go through them. The first one, this is from August 2022. Nedbank was hit with a 35 million rand fine for not complying with certain administrative provisions of the Financial Intelligence Center Act. Naughty, naughty Nedbank. But in case you're thinking I'm picking on Nedbank, let's go on. Standard Bank fined 30 million in 2019 for not having strong enough money laundering controls. South African Reserve Bank obviously imposed these administrative sanctions. And in case you think I'm just picking on Nedbank and Standard Bank, we go all the way back to 2014. SA Banks, cumulatively the top um, four banks, yes, the four largest banks, total fines of 125 million rands for inadequate anti-money laundering or AML procedures. So FICA, obviously, as we know, attorneys specifically, a very, very hot button issue at this stage in terms of compliance with anti-money laundering, anti-terrorism, etc. So let's go on to another one. Judge slams UNISA in a 1.2 million rand compensation case. This refers to unfair labor practices or alleged unfair labor practices, which made their way all the way through the CCMA, all the way to the Labour Court. And this was also a fairly recent cautionary tale. And this is one from the United States, which I thought was quite amusing. Farmer owes $82,000 in a contract dispute over the use of the thumbs up emoji, according to a judge. And what had happened here was a transaction was in the process of being negotiated. One party sent a draft memorandum of agreement to the other via WhatsApp. And the recipient party reciprocated the receipt with a thumbs up emoji, and a huge fight ensued as to whether the thumbs up means that they simply confirmed receipt, as was alleged by the recipient, or whether it means that they agreed to the terms of the agreement. And I suppose loose lips sink ships, or loose emojis sink ships in this case. So based on the short video that we had a look at and the cautionary tales which I shared with you, I'd like to first off go into the definition of a business blind spot. And this is what I believe to be a fairly sound definition of business blind spots. And it reads as follows. Business blind spots refer to overlooked or unanticipated challenges, particularly legal vulnerabilities within a company's operations or strategies. These often result from lack of knowledge, and they often also result from inattention to areas, and all of these may put the company at risk. Unaddressed, blind spots can result in legal exposure, financial loss, and obviously harm to the company's reputation. Identifying and addressing business blind spots proactively can significantly enhance risk management and contribute to business longevity and success. Now, is it possible? And this is the question that I suppose is on everyone's minds. Is it possible to cover oneself for every single eventuality? And obviously the answer is no. However, one can to a great extent ameliorate one's risks and one's exposure by being mindful of these risks. Nadia, I see you've got your hand up.
I'm very sorry to interrupt. I just want to say and ask if anybody can just reply in the chat bar if they are having a problem with hearing Merv every now and then, because I am struggling at the moment and your video is very choppy. So I just want to. Okay, so if we don't have any issues, that's absolutely fine. That's my indaba. So sorry for that.
That's fine. You hear my voice enough, so you're not going to miss too much. But as long as our esteemed attendees are hearing us, but as Nadia indicated, please, if you are having issues hearing me, please do let us know. All right. So let's now that we've defined a business blind spot, go on to a few other issues, but before we get there, please could I do a very, very shameless plug for some of our upcoming webinars. Please indulge me with 2 minutes to take you through them. Nadia is quickly going to just paste in the chat bar full details of all the webinars that are coming up, and boy, oh boy, do we have quite a few exciting webinars in the foreseeable future. For those of you who registered, you would have received the list of webinars and their registration links in your registration email. Right, that being said, let's quickly run through them. The first one coming up on the 4th of August, in 2 weeks' time, we are going to be talking about demystifying pension interests in divorce. I've found that this is a big problem, and it is a very, very often misunderstood issue. Presented by myself, I'm going to be joined by Tanya Abbott. She is an attorney from Hammond Pole Attorneys, dealing also with a lot of family law matters, and she's specifically going to be talking about living annuities. She was involved in a matter a few years back where a very interesting judgment came out from the SCA, and she's going to tell us a little bit more about that. And then also from a practical point of view, we will be assisted by PBA Financial Services, who will be talking about some of the more administrative elements of pension interests. Then 10th of August, this is a lunchtime learning event presented by Steph Dawson-Kossa. It is called Discover the Power of Thought, an Introduction to the Thinking Environment. This is a very, very important topic for those who deal with families in distress, such as mediators. And Steph, who is a coach as well as a mediator, will be talking about the benefits of mindfulness and thinking in terms of these types of matters. Incidentally, both of the webinars that I mentioned to you just now are absolutely free of charge, so please do feel free to register. The 18th of August, we've got Personality as Your Superpower, Unlocking Success as a Family Professional, which is going to be presented by Mr. Louis Negrini, who is a business coach and a fantastic public speaker. He is going to be talking about the DISC personality groups and how family professionals can leverage their own personalities to better conduct their practices. Then on 1 September, I'm very pleased to be joined by Sunay Albrecht, who is an attorney and a conveyancer, and she is going to be talking about conveyancing basics for family professionals. Then on the 15th of September, I'm very pleased to announce that we've partnered with Fair Practice, and specifically Advocate Virash Shrikeson, who is going to be presenting a presentation specifically for mediators around unconscious bias. This is not a free session. It is 200 Rand for the session. However, it is CPD accredited for 2 SARM CPDs, which are obviously NABFAM CPDs, and also 2 CPDs with the South African Board of People's Practices. And then finally, later this year on the 29th of September, I will be presenting my Children's Act Deep Dive, which I developed over a few years. It is accredited for SARM CPD points for good old 5 CPDs, which you will get for spending the day with me. First time attendance is 750 Rand. Returning attendees get a discounted rate of 375 Rand. This is a deep dive into the Children's Act, looking at all of the major concepts relevant to family professionals. Right, so after that shameless plug of upcoming events, let's go on to common blind spots. Now, folks, the question you might be asking yourself is the following: what is the biggest danger to your business. And I would unequivocally say the biggest danger to your business is this guy. Well, not really this guy. This guy is an actor, but this guy plays this guy. And this is obviously Daredevil from the Netflix series. And what I would like to focus on is the first 4 letters, DARE. And this is an acronym which I've been working on and developing in terms of better understanding business blind spots for the last couple of months. And I'd like to take you through it. So please, for those who are fans of the show Daredevil, please do not complain to Netflix that one of their actors will be ruining your business. What is important is the word DARE, and it is an acronym which stands for the following: debt management, agreements, regulatory compliance, and then finally employee relations. And I've obviously put in there for you folks a few warning signs, because these are your warning signs. My favorite one on the left is be careful, no playing, and I think it is spot on when it comes to issues of blind spots for your business. We should not be playing. Right, so let's quickly look at how this fits into a business, and what I would like to call it is the line of sight dilemma. And what I say is that human beings are not owls. For a couple of reasons: we don't have feathers, we don't have wings, but most importantly, we cannot turn our heads 180 degrees. So I've illustrated on the screen in a very rudimentary way the idea of a business owner, which is illustrated there by a person in the middle of the screen, and the blue triangle represents the line of sight of our person in the middle of the screen. Now, obviously, as a business owner, business manager, etc., one's focus should always be on your primary scope of business. However, unfortunately, since we do not have 180-degree vision or 360-degree vision, apologies for that, at all times, the unfortunate upshot of keeping one's eyes on the prize of your primary scope of business leads to these 4 issues being neglected: regulatory compliance, agreements, debt management, and employee relations. And one is reminded of, for those of you who are children of the 80s and 90s, you'll remember in the first Jurassic Park movie where the hunter is focusing and aiming down his scope at this herd of dinosaurs standing right there below, and the next thing he looks to his left and there is the raptor standing. And these are, this I believe is quite illustrative of one being so focused on what you need to do within your business that you don't look out for these issues which may come out of nowhere and severely and profoundly ruin your day. So what I'd like to do now is to go through the 4 main issues. As I indicated to you, it's under DARE, it's debt management, agreements, regulatory compliance, and employee relations. Now, obviously, folks, this is not an exhaustive list. If we were to do an exhaustive list, I would have to present a 6-month course on this, and obviously none of us have time for that in this fast-paced world that we live in these days. But I have found in my 10 years of practice acting for businesses that these are really the 4 places where the proverbial pawpaw hits the fan most often, and where businesses most often suffer loss due to lack of adequate preparation and lack of adequate planning in terms of risk management. Now, let's talk about debt management. So, what is debt management? Now, I've postulated a very, very short definition, and now just understand, folks, debt management is not debt collection. Debt collection refers to, thanks Francois, sound and visuals intermittent. I'll just give it a few seconds. Hopefully it recovers. And I think let's run again. If it's still a problem, please do let me know. Debt management is not just debt collection. Debt collection is the band-aid. Debt collection is the treatment. However, unfortunately, that often comes too late. It is very often very difficult, alternatively impossible, to collect on debts if adequate arrangements have not been made by the creditor or the business to ensure that those debts are recoverable. So there is a planning element and an enforcement element to debt management. And in short, we can say that debt management refers to the strategies and processes a business employs to ensure timely repayment of debts by its customers or clients. Incidentally, folks, I will be using the words customers and clients interchangeably, obviously referring to the same general principles. The aim of debt management is to mitigate the risk of bad debts, to maintain positive cash flow, and to ensure financial stability. Now that runs the whole gamut all the way from planning stage, getting your intake agreements for clients ready, your terms and conditions, etc., all the way through to how you invoice, when you invoice, and what your payment terms are, all the way through to your legal collection stage and everything in between. So let's talk about some systems or symptoms, not systems, my apologies, of poor debt management. And I hope to keep this a bit more interesting, so I've put in some cartoons as a very rudimentary attempt at levity when talking about a frankly depressing topic. So what's the first symptom of poor debt management? Cash flow, specifically the lack thereof. If you are dreading the last week of the month for salaries, rent, phones, debit orders, one of the first places that you need to start troubleshooting is your debt management. Because if you are busy and you are invoicing enough, the reason you don't have money is because you are not getting paid. And none of us wants to turn out like this poor company having to ask just how bad is our cash flow problem when spending the first dollar of profit which was framed against the wall. So if you are struggling to get through your month, if you have more month at the end of your money, as they say, have a look at your debt management when you start troubleshooting, as this may be one of the first symptoms of poor debt management. A little bit of an interactive one. Those of you who are willing to give away your age, can anyone recognize the character that I've got on the screen right now? Let's see who's willing to give away their age. Whilst I tell you what the second symptom of poor debt management is, it is book debt. Stella, thanks very much. It is not Popeye. It is from Popeye. However, anyone else want to take a whack at who we've got? Going on. This is a gentleman by the name of Wimpy, which is one of the interesting things I realized yesterday, because I've always been wondering where the Wimpy franchise got its name, and I suppose this may be a good hypothesis. Now, Wimpy was a very interesting character because he had a very recurring catchphrase throughout the Popeye cartoons, and I won't press you guys to tell us what it is, but it is the following: I will gladly pay you next Tuesday for a burger today. And later on in the Popeye comics, it turns out that he never goes to the restaurant on Tuesdays. Now, a lot of us, unfortunately, are faced with clients who are much like Popeye, who want to have something today to pay at a later stage, and we end up, unfortunately, sitting as business owners with vast amounts of book debt on our balance sheet, but no money in the bank. And obviously, as we all know, book debt does not necessarily put food on the table. So if you find that you have a spiraling debtors book, if you, like I did 5 or 6 years ago, take a look at your debtors book and go, sure, if I get all my debt in, I don't have to work for 2 months, you may have a book debt problem that you need to resolve. And thank goodness I managed to resolve it way back when. But please have a look at your book debt. If it is spiraling, one of the areas where you really need to focus as a blind spot is debt management. Now, final symptom of poor debt management, which I'm going to deal with, and obviously there are more symptoms, but I'm highlighting the most obvious ones or the most prevalent ones, is excessive invoice queries. And I like the, yes, sir, we're dealing with your invoice at this moment, and the little guy burning it in the background. What happens or what leads to an invoice query? Very simple. It's a disconnect in expectations. If you are not billing in accordance with what your client expects, or you do not adequately communicate the cost of your services or your products to your clients beforehand and have them commit to it properly, you will unfortunately be faced with excessive invoice inquiries. There will always be invoice inquiries. We know there are chances out there. The attorneys who are in today, I'm sure, will attest to that. But if they become excessive, have a look at your intake process. Are you effectively communicating your costing to your clients beforehand and getting their buy-in? As I indicated at the introduction of this section, debt management is much more about planning and prevention than it is just about chasing up debts by means of lawyers and or debt collectors and or gentlemen with big baseball bats. So if you want some more info on this, there are 2 QRs. You're welcome to scan them now. However, I will be distributing on Tuesday the recording for today's webinar to everyone who registered, as well as the slides in PDF. You'll be able to scan them there. There is a link on the left-hand side to a blog article on the topic, which gives some tips of how to troubleshoot your debtors book and your debt management within your business. And then also on the right-hand side, we have a YouTube video of a webinar done a few years back by Kathleen Breert, one of the attorneys at my firm, on top tips for a ship-shaped debtors book, which also gives you a good starting point to start whipping your debt management into shape. Now, let's talk about agreements. Now, agreements can have various forms. An agreement, as we know, is a binding contract between 2 individuals or 2 entities, whether they are natural persons or juristic persons, which sets out the obligations and the rights of the respective parties. It's usually a very reciprocal document, and it can be as simple or as complex as the parties to the agreement wish. Now, very often business owners are very focused with the contracts between them and their clients. However, there is an extra element to this as well. Those of you who are leasing premises, there is usually a contract in place. On a more simple level, those of you who have a cell phone, there is usually a contract in place. Contracts can go from very, very simple, very, very basic, low-risk contracts to very, very high-risk, very sophisticated contracts. So how I've defined agreements within the DARE framework, remember, debt management, agreements, regulatory compliance, and employee relations. In this context, I have defined agreements refers to the drafting, review, and modification of various business contracts and third-party agreements to provide legal security and clarity in business transactions, thereby minimizing the risk of disputes and potential legal issues. Now, how do you know if you have a problem with your agreement management? I really like this cartoon. Scott, you'll be disqualified the next time where you say we'll just have to agree to disagree. I thought it was quite relevant because in a business dispute, unfortunately, one doesn't have the luxury of saying, let's agree to disagree. I owe you the money or I don't owe you the money. We can't agree to disagree. So the first symptom of poor agreements management is excessive disputes with providers, associates, and clients. If you spend half of your day bashing away at your keyboard, fighting with clients or suppliers, you may have difficulty with managing your agreements, either in the form of insufficient agreements being in place or in the form of not having a clear understanding of the agreements to which you are a party. And we'll go into that a little bit later. Second symptom of poor agreements management is uncertainty, uncertainty everywhere. If someone asks you on which day of the month you need to pay your office landlord and you say, sure, I don't know, I usually just pay around the end of the month, you may have an uncertainty problem. Do you have uncertainty about your exact obligations and rights? Now, this is a very interesting topic when one talks about agreements, because obviously agreements can permeate the sphere of debt management as well as employee management, because both of those relationships vis-a-vis the business are regulated by agreements, presumably. If you don't have agreements with your employees, that is your indaba, and we'll talk about that a little bit later. But the idea of agreements does overflow a little bit into the realms of debt management and employee relations. So the second primary symptom of poor agreements management is a sense of uncertainty prevailing. Right. And then the third one is excessive reliance on gentlemen's agreements. I've heard it said many a time that those who insist on gentlemen's agreements generally are not gentlemen. And there's a nice cartoon from the United States Senate with our Democrat and our Republican at each other's throats saying our gentleman's agreement is broken. And obviously, folks, the problem with gentlemen's agreements is uncertainty, number one, and secondly, enforcement issues and interpretation issues which arise, which we'll look at a little bit later. We're making fairly good time. We're about 40 minutes into the webinar. I have 22 slides left. We're on slide 33 now. Thank you for everyone who's sticking around. I hope that I am making it fairly engaging. This could be quite a dreary topic, so I really do hope that you are enjoying some of the levity that I've put in. So on this note, there is, for further information, I've linked to a previous webinar we did, which dealt with the contract basics for small businesses. And in that particular webinar, Kathleen Briet, as with the previous webinar, focuses on business contracts, which are the contracts that you should know about, and how do you implement them in your business? How does everything fit together, in essence? So, right, let's move on to regulatory compliance. Now, regulatory compliance is excessively broad, folks, and I will take you through that a little bit later, but in short, in terms of a definition, regulatory compliance refers to a company's adherence to laws, regulations, guidelines, and specifications relevant to its business processes and practices. It involves ensuring that the company meets all legal obligations, often through the implementation of processes and procedures that assist in maintaining compliance. Now, I would love to take you through the symptoms of poor regulatory compliance. Unfortunately, regulatory compliance, or the lack thereof, is completely asymptomatic. And what I mean by that is the first time that you know that you are not FIC compliant is when the LPC knocks at your door, or the FIC knocks at your door saying, we want to review your FICA manual, and you don't have a FICA manual in place. Similarly, if the Department of Labor sends you your letters saying, we want to inspect your employee contracts, your leave policies, your pay slips, etc., it is the silent killer for businesses. If you do not adhere to legal and regulatory compliance, you may be in big trouble without knowing it. We'll go into that a little bit more at a later stage. And then finally, in our DARE acronym, as I'll repeat it, Debt Management Agreement, Regulatory Compliance, and Employee Relations. Obviously, we now go on to employee relations, being the final part of our acronym. Now, employee relationships, apologies, my heading at the top is incorrect. It's not defining agreements, it's defining employee relations. It refers to the efforts of a company to manage relationship between the employer, i.e. the company, and employees. An effective employee relations strategy includes maintaining a positive, ethical, and transparent work environment while resolving workplace issues. It involves aspects such as drafting and reviewing employment contracts, disciplinary codes, company policies, handling disciplinary inquiries, retrenchment procedures, and negotiating with unions. Sure, that was quite a mouthful, obviously. As we know, in most businesses, the employees are the business's most important asset or constituent part, and poor employee relations can be particularly damaging to a business. Fortunately, folks, the employee relations leg of our DARE framework is one of the very early onset symptomatic issues. And what I mean by that, and let's compare it, for example, to debt management. If you have a cash flow problem, the symptom is immediately apparent. You see it in your balance sheet and your monthly management accounts, etc. Same as with the debt management aspect, employee relations is very, very acute. If you have an employee relations problem, boy, oh boy, you are going to know it very, very quickly. The first symptom of poor employee relations is a toxic or an unpleasant working environment. If your year-end function looks like this photo, you may have a problem with employee relations within your company. If you have consistent underperformance by employees, you may have an employee relations problem. If you find you're paying salaries only to be left doing the work yourself and after hours to the detriment of your personal life, the most likely culprit is poor employee relations and poor employee management. And then the final symptom of poor employee relations, which I'm going to look at today, is a low staff retention rate or a high staff turnover rate. If your employees walk in, say hi, and next week they say bye, you probably have a problem with the employee relations aspect of your business. Now, folks, I've looked at a few symptoms under the DARE framework. As I indicated to you, debt management agreements and employee relations all have very acute symptoms, and unfortunately, regulatory compliance is, for the most part, asymptomatic. So what I'd like to do next is I would like to go into some rookie mistakes. And I hope that none of us are making these rookie mistakes. And I invite you to have some introspection. Now, these rookie mistakes are based on issues which we've seen in our practice, which really crop up very frequently in legal matters. And let's see if they apply to you or not. I have, in terms of the rookie mistakes, I've decided to share some interesting tattoos with you. And the first one that we've got here is our dear person who decided to tattoo "no regrets" on their arm. I am sure they are regretting getting that tattoo, unfortunately. So let's look at our common blind spots. Failure to, under debt management, implement a standardized client agreement. This also extends to issues such as terms and conditions, whether it is printed on an invoice displayed at your offices, in the footer of your email, etc., etc. If you do not have a standardized set of terms and conditions regulating your business relationship between you and your client or your customer, you have made a rookie mistake, which you may end up regretting, as the tattoo says. If you extend credit, or if you're on 30-day accounts, if you do not adequately perform vetting on potential clients, you are opening yourself up to a world of heartache. And I'm seeing it more and more, especially with attorneys' firms who are doing payment arrangements with clients, and later it becomes apparent that the client may be under debt review and the attorney has then fallen foul of the National Credit Act. Do you know whether the address given by your client is a legitimate address? Did you go on Google Maps to check? Is there a building? Is it a vacant plot of land? Do you know whether your client has any judgments against them, etc., etc.? Right. If you do not invoice frequently and consistently, you are doing yourself and your client a disservice, because the working relationship is immediately not transparent, and there is no reciprocity. If your client does not receive invoices, they cannot pay you, and you are not entitled to take their money from trust if you are an attorney without an invoice or a tax invoice as a corollary document to the funds held on trust. So do invoice frequently and consistently, and do indicate to your clients how frequently and consistently you will invoice. Let them know beforehand when they can expect their invoices and stick to it. By way of anecdote, my practice invoices every week on a Friday. We do our automatic invoice run, which goes off to clients every Friday, so they are aware of exactly what happened in the preceding week on their matters, and they are not victim to accounts spiraling out of control. Fourth rookie mistake, failing to keep track of client accounts. Client accounts very often, especially in the services industry, can spiral very quickly. And it saddens me to say that the two professions which one would think would be very good with watching their accounts are the two biggest culprits, and these are attorneys and accountants. We see very frequently that these accounts often spiral out of control due to failure by the service provider to keep an eye on what's going on the account. Then a very less, or much less obvious one, sorry, that's very good English on a Friday morning, a much less obvious one, and one that I think most small businesses are quite guilty of, is a failure to train staff on best practices. Where I have seen this really prejudicing clients in the past is where they would send us an agreement and say, no, don't worry, the director signed surety, and you go to the surety section and it's blank. And you say, no, they didn't. They didn't sign here. And your client then ends up suffering for it because the person who does the vetting or the client onboarding did not do what they were supposed to do. So those are our 5 rookie mistakes to avoid when it comes to debt management. Let's go on to agreements. This one was one of my favorites. Someone clearly transposed an E with an A and lost the message of the tattoo completely. It's a bit of a naughty one, but I hope you enjoy it. So let's look at our agreements. And I put this specific tattoo in with agreements because you have to read very, very carefully that the agreement accords with what you think it says. Rather read sweet pea than sweet pea. And let's go through our rookie mistakes. If you fail to understand contracts before signing them, you are letting yourself in for heartache. There are a few contracts which I know very few people read, which end up really biting them in the long term. A few notable examples are office automation contracts, digital service provider contracts, and cell phone contracts, obviously. Very often people are bound for periods of time with escalations that they did not discuss and that were not explained to them, and they get bound to unfavorable terms by simply signing on the dotted line. If I were to ask you right now how many contracts govern your business with suppliers and with clients, and you are unable to tell me which contracts there are and what your obligations are in terms of those contracts, you may have a big problem in terms of your agreements management. This is one of the rookie mistakes. What I've implemented is to run an Excel spreadsheet to say, here is the service provider, these are the basic terms, this is when the agreement terminates. And as the agreements terminate, I just take them off of the spreadsheet so that you know at all points where you are and what your obligations are. If you don't revise your standardized contracts regularly, you are setting yourself up for failure. As we know, the law evolves, and we need to keep up with the evolving and changing legislation, regulations, etc., in terms of our standardized agreements. And by standardized agreements, there can be a number of different documents. Most obvious, your employee agreements or your employment contracts, supplier agreements, client agreements, etc. And then the final rookie mistake: if you fail to negotiate, you are prejudicing yourself. When it comes to contracts, everything revolves around negotiation, and you'll be very surprised how much better you can do in terms of contracts if you take the time to negotiate with service providers and or clients. It's an unfortunate thing in South Africa. We're not properly taught to negotiate. Right. Regulatory compliance. I really like this one. Someone got their first tattoo and called it their first tattoo. The story behind this tattoo is when the person actually went to have it removed by laser, it was so bad that they thought it was a joke. So, failure to understand which laws, regulations, and best practices are applicable to your business. Do you know what the impositions are on your business? For attorneys, for example, FICA, HOPI, your LPC Code of Conduct, Legal Practice Act, etc., etc. All of these are issues which are applicable. If you are in a particular industry, you should know which laws, regulations, and best practices are applicable to your business. If not, you may fall victim to the silent killer of regulatory compliance, which, as I indicated earlier, is asymptomatic. You only realize that you were not compliant when it is too late. If you fail to comply with regulatory compliance or regulatory requirements, you are making a rookie mistake. If you know you should have a PIA manual and a POPI manual and you don't have one, you are setting yourself up for failure. If you know you have to give your employees pay slips with their salaries every month and you don't do so, you're setting yourself up for a visit from the Labor Department. If you know that you are working with personal information and you don't have a POPI process to keep that information safe, you are setting yourself up for an issue with the information regulator. If you don't have an information officer registered, you're setting yourself up, etc., etc. Then, if you do not frequently update your regulatory documents and processes, you are also looking for trouble. And this last tattoo is my absolute favorite one. It Is My Life by John Bovey, that very famous 80s and 90s rock band. It is my life. And very often employers think it is my life and they do whatever they want, and they end up at the receiving end of a CCMA case. First rookie mistake: if you have a verbal agreement with your staff members, you're looking for trouble, then your employee relationship is governed by the Basic Conditions of Employment Act, and you have very little insight into the actual terms and conditions, which would work for both employer and employee. You would be held to a standardized piece of legislation, which might not be ideal for you. If you as a business do not have a clearly defined disciplinary code, you are looking for a CCMA award against you. If you do not provide staff with clear and unambiguous job descriptions, similarly, you are looking not only for trouble with the CCMA, but also trouble with your business management, because staff who are uncertain about what they need to do are incapable of doing it effectively. Finally, if you fail to constructively communicate with staff members, you've got problems, and then obviously failure to comply with the Labour Relations Act and the Basic Conditions of Employment Act. Folks, I've got another 8 slides. We've been going for an hour now. I know we are all getting fatigued, but we are almost there. Please do bear with me. Right. So let's look at some of the legal requirements under the DARE framework. So for sake of repetition, for some of the people who just joined us, I see there were a few who just signed on. DARE refers to debt management agreements, regulatory compliance, and employee relations. It is a useful framework within which to group the most frequently encountered blind spots for businesses, whether big or small. Obviously, it is not exhaustive. There may be other blind spots, but these are the 4 big ones which generally lead to business failure and or strife. Legal requirements take 2 distinct forms in terms of the DARE framework. There are legal requirements which are of universal application, which we'll go through shortly, and then you get your sector-specific legal requirements. First, let's look at the legal requirements which are of universal application. Now, these are issues which you really can't sidestep by being in a specific industry versus another industry. It is applicable simply to all business in some way, shape, or form. Under the DARE framework, I've indicated a couple. Under debt management, we have the National Credit Act and we have the Prescription Act. National Credit Act, biggest parts of relevance there is if you are extending credit, deferred payments, etc. You do need to know what your rights and obligations are in terms of the National Credit Act. There have been substantial changes to the registration requirements of credit providers with the National Credit Regulator. Prescription Act of 1969. If you leave a debt for more than 3 years, you will probably end up having some serious issues. And also, just to kind of edify the position a bit, in terms of some of the more recent amendments to the National Credit Act, it is in fact unlawful to collect on debts that have been prescribed. Under agreements, I've listed 2 aspects. The common law principle of caveat subscriptor, which means that if you sign an agreement, it is accepted that you understand the agreement and that you agree to be bound thereby. And secondly, the common law principle of pacta sunt servanda, that agreements should be upheld. Regulatory compliance of universal application, POPI and PIA. Most businesses need to have a POPI and a PIA manual these days. Value-added tax, for example, and other income tax legislation. We talk about pay as you earn, etc., etc. And then under employee relations, we look at things like the Labour Relations Act, the BCEA, and COIDA, the Compensation for Injuries and Diseases Act. So, or Compensation for Occupational, apologies, in Injuries and Diseases Act, sure. Then from there we move to sector-specific legal requirements, and these are much more industry-oriented. So, for example, restaurants have health and safety requirements and hygiene requirements. Attorneys have FIC, POPI, etc. And throughout the various different industries, there are laws, regulations, best practices, and guidelines to adhere to. I'm not going to go into specifics here. It is simply too broad. But the point remains, if you are in a business in a particular sector, know what your requirements are. Then the final part, and we're in the home stretch now, folks, checking your blind spots. How do you check your blind spots? How do you know where your risk lies? Especially for small businesses, it can become quite an onerous thing, insofar as you cannot manage what you cannot measure, and you cannot measure what you cannot see. And that is where I would like to introduce you to the business blind spot audit. This is something which I've devised together with my team over the last couple of months, which I will tell you about fully on the next slide. Right, ladies and gentlemen, solar helps very little when you overload your system. Can I just get a thumbs up? Can everyone see me struggling here in the dark in my study? Can everybody hear me? All right, excellent. Let's roll with the punches. My internet should be up and my light should be up in the next couple of seconds. It usually takes about 20 seconds for the system just to reboot itself. So from my side, as I sign off on my cell phone in my very, very cluttered home office, I do thank each and every one of you for taking the time to join me on this journey as we delve into business blind spots and into how to prevent and mitigate loss for our businesses. So Philip asks, what specific industry regulations impact on rental property industry? I won't go into an exhaustive list, Philip, but off the top of my head, there are obviously your requirements in terms of the EAAB, erstwhile Estate Agency Affairs Board. There are various other portions of legislation in terms of Sectional Titles Act, for example, in terms of levies, electricity, maintenance, etc. And obviously the standard ones, your POPI and all of those aspects also come in. Philip, if you would like, I'm more than happy to engage with you just to go into the big specifics. Anka asks, where can we get a copy of the checklist? So what's going to happen is next week when we send out the recording, I will be also distributing the link to access the business blind spot audit for everyone who attended. And not to worry, I will be sharing my slides as well as the recording for the presentation. So from my side, folks, thank you so much for joining us. I'm not going to go over to the computer as we sign off. It would just waste unnecessary time. I thank you all for being part of this webinar today. Those who have not yet joined our WhatsApp groups, please go and look in the chat bar for the links. Join our WhatsApp groups, join the conversation, and be part of the wider knowledge base as we all seek to educate one another. And please have a look out for our upcoming webinars. I wish you all a lovely weekend. Stay safe, keep warm, and look out for our email on Tuesday. I have been Mervyn Vermeulen, for the most part speaking to you with electricity, for some parts speaking without electricity, but hopefully you will all think that I'm quite bright. I don't know, maybe, we'll see. That was a silly pun on a Friday. Have a great weekend, everyone. I will see you all soon. Goodbye.